The three primary causes of excessive litigation cost are built into the basic structure of our antiquated public court system. To avoid that inherent cost inefficiency, you must choose a superior system for deciding your legal dispute.
Hello, my name is Rick Grossman, and I am the founder of the nonprofit enterprise Intelligent Justice, which is dedicated to solving the enormous problems faced by the parties to a legal dispute that seek a just resolution through our antiquated court system or traditional arbitration. In this video post, I will discuss the three primary problems that lead to the excessive cost of litigating legal disputes in a public court or a traditional arbitration. Intelligent Justice's alternative, Comprehensive Adjudication, solves all of those problems. The first problem is the cost of multiple attorneys duplicating each other's work. In the public court system, or in arbitration, each party hires a separate set of lawyers to research the same statutes and legal authorities, to carefully review the same documents and other evidence, to examine the same witnesses at the same pretrial depositions, to analyze the same law and evidence in written briefs to the court or arbitration panel, to attend the same court or arbitration hearings, and then to participate in the same trial many years down the road. This problem is built into the basic structure of the traditional litigation system. Any good attorney representing your best interests will not just look for the law and evidence that supports your position. She also will review all the law and evidence that runs counter to your position, so she can plan how she will respond when opposing counsel raises the troublesome law and evidence in court, and advise you to settle the case when the law and facts do not support you. So the attorneys for each side of the dispute duplicate each other's work because all of them look at the law and evidence that both favors their client and runs counter to their client's position. And this problem is even worse in a traditional arbitration proceeding, where in addition to paying their separate attorneys, the parties also must pay expensive arbitrators to consider the same evidence and to listen to the same testimony. A comprehensive adjudication solves this problem by using a single neutral adjudicator to vigorously investigate the law and facts favoring all parties before deciding which party deserves to win in an enforceable decision. The cost of that single neutral expert adjudicator is split by the parties instead of each of them paying their separate attorneys to duplicate each other's work. By itself, this simple change guarantees that the cost of obtaining an expertly analyzed enforceable decision resolving the dispute is half the cost of litigation or arbitration, and often much less than half. But that is not all. A comprehensive adjudication provides even more cost savings by solving the additional problems with traditional litigation. The second problem with the cost of traditional litigation is caused by the need to repeatedly present the same evidence over and over again. It begins with a lawyer's use of so-called discovery procedures to force the disclosure of relevant documents and examine the witnesses under oath in lengthy pre-trial depositions in the attorney's private offices. That same evidence and witness testimony often is reviewed and analyzed again by each party's expensive and separately paid expert witnesses. The same evidence and witness testimony is presented again to the judge in support of multiple pretrial motions. The same evidence and witness testimony is presented again to the judge and a jury several years later at trial. And the same evidence and witness testimony is often presented again when the trial verdict is later appealed to an appellate court. A comprehensive adjudication proceeding eliminates the need to pay for multiple presentations of the same law and evidence by using a single, jointly selected, expert neutral adjudicator to both investigate the facts and decide the case. The adjudicator can properly decide the case after reviewing the evidence and examining the witnesses just once. There is no need to pay for separate motions to a public court judge or for an expensive separate trial many years later. But that is not all. A comprehensive adjudication provides even more cost savings by solving another problem with traditional litigation. Yes, the final problem with the cost of traditional litigation is caused by the attorney's motivation to engage in dozens of expensive procedural battles that have nothing to do with the merits of the case, but instead focus on how and where the case will be presented. These procedural battles take the form of lengthy written motions to the court, involving such things as jurisdiction, venue, scheduling, permissible allegations in the pleadings, the proper scope of evidentiary discovery, attorney-client privilege, confidentiality, status conferences, protective orders, juror questionnaires, the proper scope of expert witness testimony. The list goes on and on and on. In fact, it is likely that your attorney will spend most of her time and client money on battles designed to obtain some procedural advantage over her opponent, because that is what she has to do to win in our public court system. But these battles have nothing to do with who legally deserves to win the dispute and who deserves to lose. A comprehensive adjudication eliminates all of the unnecessary time and cost spent on these endless procedural battles because there is no opportunity for one side or the other to obtain a procedural advantage. Instead of wasting time and money on procedural issues, the neutral adjudicator focuses on vigorously seeking and seriously considering all of the relevant law and evidence supporting the substantive positions of each party before deciding which of them legally deserves to win. Because comprehensive adjudication eliminates the need for each party to hire separate attorneys to duplicate each other's work, it mathematically reduces the cost to each party by at least half. But a comprehensive adjudication also eliminates the other major inefficiencies of litigation, which leads to substantial additional cost savings. In my next post, I will explain how, unlike traditional litigation, the total cost of a comprehensive adjudication proceeding can be capped at the very beginning of the case.